Last week, we spoke about the development of American law. Positive law, natural law, precedent, and stare decisis, to name a few. This week, we are going to learn about some key structures of American law. We saw with the outbreak of COVID-19, the federal government passed stimulus packages to businesses and individuals, and each state handled its shutdown and reopening differently, from how long to shut down to deciding which businesses will be affected. Who was responsible for supporting the citizens and businesses during that time, and making decisions such as which businesses should shut down and for how long. The concept that comes into play here is federalism. Federalism is the division of authority between the national government in Washington, D.C., and the 50 state governments. Each of the states has its own government and its own constitution that grants and limits its powers. All provisions of state constitutions and the state statutes are subordinate to the United States Constitution and laws adopted by Congress. What does this mean? If a state law conflicts with a federal law, the federal law wins out, as the federal law is supreme. Does this always hold true? In Obergefell v. Hodges, the U.S. Supreme Court legalized marriage across the country. All states legally had to abide by this law, even states like Alabama, whose law was to deny same-sex marriage. The reason? Federal law preempted state law. We still saw Alabama judges refuse to sign same-sex marriage certificates, even though they were legally bound to do so. How is power between the federal and state governments distributed? Some powers are granted solely to the federal government, some solely to the state governments, and some to both the federal and state governments. The federal government powers extend throughout the United States. It has the power to perform acts which affect the nation, such as making treaties, enacting laws governing high seas, coining money, regulating international trade, regulating immigration, providing for the national defense, regulating interstate commerce, and more. The authority of state governments are confined within state borders. They have the power to establish and control local governments, like cities and counties, conduct elections and apportion electoral districts, control commerce within their borders, the power of police power, the power to make and enforce laws in favor of the public health, safety, and welfare. Thus, during a national emergency like COVID-19, where the national government responds by passing stimulus packages, it is up to the states to protect the health and welfare of their citizens by determining when and which businesses should close down and open back up. Powers that both the federal government and states share are called concurrent powers. These include the power to tax. We know this as we pay both federal and state taxes. the power to spend and borrow money, the power to enact legislation. There are both federal and state laws, the power to regulate banks, the power to establish courts of law. We know there are both federal and state courts, and the power of eminent domain, which is the power to take private property for public use as long as there is just compensation. The national government and each of the states have their own legal system. So in total, there are 51 legal systems. Each system is based on a constitution. There is the U.S. Constitution, and each state has its own constitution. Like the U.S. Constitution, each of the 50 state constitutions is based on the principle of separation of powers, where government power is distributed among the legislative, executive, and judicial branches. Each system has a legislature empowered to enact statutes or laws. Each system has its own government law office, for example, an attorney general's office. This is part of the executive branch. Each legal system has its own system of courts. Legislatures are responsible for enacting laws. The people elect members of the legislature through free and fair elections. As many of you know, our national legislature is called the U.S. Congress. Congress has substantial amount of power according to the Constitution. It has both enumerated powers, which are powers specifically granted to it by the Constitution, and implied powers, which are powers implied in order to carry out its enumerated powers. An example of an enumerated power is the power to tax and regulate interstate commerce. This is spelled out in the Constitution. An example of an implied power is the power that Congress may allocate money to test a missile defense system, something not specifically listed in the Constitution because Article 1, Section 8 gives Congress the power to raise and support armies. Thus, Congress can justify the allocation of money under its implied powers. Here is another item you may recall learning in middle school or high school: how a bill becomes a law. Either the House of Representatives or the Senate introduces a bill. Both houses of Congress must pass a bill. A majority of votes is needed. The bill is then sent to the president, and the president can either sign the bill into law or veto it. 2/3 of a majority of both houses of Congress can override the veto. Last week, we discussed precedent and stare decisis. Let's talk more about judicial systems. The federal government and 50 states maintain their own system of courts. These systems include trial courts and appellate courts. The trial courts conduct civil and criminal trials and hearings. They make factual determinations and settle legal disputes. The appellate courts hear appeals from trial courts. Appellate courts do not engage in fact-finding, but review legal proceedings and correct any court errors. The federal court system is made up of district courts, U.S. Courts of Appeal, and the United States Supreme Court. The district courts are trial courts in the federal system. They conduct trials and hearings in civil and criminal cases. There are over 90 federal judicial districts throughout the United States. The U.S. Courts of Appeal are intermediate appellate courts. They are also known as circuit courts. The nation is divided into 12 circuits. The circuit courts hear appeals from the district courts within their circuits. Arizona is located in the 9th Circuit, so the district courts in Arizona appeal to the 9th Circuit. How do you know what circuit each state is in? There is a map which tells you. Appeals are normally decided by panels of 3 judges. They don't have to all agree. A majority decides the case. The U.S. Supreme Court is made up of a Chief Justice and 8 Associate Justices. The court's appellate jurisdiction, which means the court can hear the case on appeal, is exercised through a writ of certiorari issued at the court's discretion. This means the court can hear the case on appeal, but does not have to. If a case raises a substantial federal question, the Supreme Court usually decides to review it. The court has broad authority over whether or not to accept a case. All 50 states have its own court system. State courts hear all types of cases, from criminal cases to torts, to family law disputes and property disputes, to name a few. State courts are broken down into trial courts, which is the first level, appellate courts, which is the second level, and state supreme courts or courts of last resort, which is the last level. All courts can be divided into 2 categories: criminal prosecution and civil suits. Remember, there can be both a criminal prosecution and a civil suit, which arises out of the same case. In the O.J. Simpson case, there was a criminal case against O.J. for murder and a civil case against the victims' families for wrongful death. Now, the punishment is different for a criminal and a civil case. For a criminal case, if the defendant is guilty, the court can sentence the defendant to a variety of punishments. In a civil case, if the defendant is liable, the court can award damages. In other types of civil cases, courts can also issue injunctions, which is to stop an act, and restraining orders. So keep in mind, monetary damages are not the only remedy available. If the defendant is harming the plaintiff in some way, an injunction might be the most helpful remedy. Law enforcement agencies have the power to investigate criminal activity, arrest suspects, and gather evidence. They are subject to limitations of federal and state constitutions. Paralegals work in conjunction with attorneys and legal secretaries. They are educated in basic legal studies and trained to assist attorneys in drafting legal documents and preparing cases. All lawyers have a duty to be professional. Clients can file grievances against attorneys for misconduct. Clients can also file malpractice suits and recover damages. The American court system follows the adversarial system of justice. This separates the function of gathering evidence from the judge's role so that the judge can remain neutral. Juries remain a vital component to the system. Many of you probably served as a juror, or if you have not yet had that honor, seen live or staged trials on TV. So you may be familiar with the order of events at trial. Opening statements, where both sides are present, followed by plaintiff's case in chief, where presentation of witnesses by the plaintiff. Next come defendant's motions. Defendant can file a motion to have the case dismissed, arguing that the plaintiff has not proven its case and the case should therefore be dismissed. Assuming that that motion is denied, next comes the defendant's case in chief or presentation of witnesses by the defendant. Next, the plaintiff can file a motion arguing that the case need not go to the jury, that the defendant has not disputed any of the plaintiff's points, and has not proven an adequate defense. Next comes closing arguments, then jury deliberation, and the jury verdict. We know that it is incredibly expensive and time-consuming to go to trial, and more parties are opting for alternative dispute resolution or alternative methods to resolve their disputes. Some of these methods are negotiation. Most litigation is resolved through negotiation. Negotiation can be without court supervision or sometime before trial. Private arbitration is a voluntary method of dispute resolution. Many agreements include provisions requiring arbitration for a dispute, so you always want to check an agreement before you sign it to see if voluntary arbitration is required. It can be either binding or non-binding. Some jurisdictions have adopted court-ordered arbitration, which is usually non-binding. Mediation is the most popular form of alternative dispute resolution. A neutral third party assists parties in reaching an agreement. Most mediation occurs while litigation is pending. The parties often agree to mediation in family law disputes, personal injury cases, and other types of cases. Experienced lawyers are often called upon to serve as mediators. The process is informal. The difference between mediation and arbitration is that in arbitration, an arbitrator makes a final decision on a case, while a mediator does not. During the arbitration proceeding, an arbitrator listens to and considers all relevant information, then decides which party should win. Essentially, the arbitrator acts as a judge and jury. In contrast, a mediator doesn't impose a final resolution on the disputing parties. The mediator acts as a middleman who facilitates discussions for possible settlements or resolutions and encourages the disputing parties to arrive at their own decision. When you think of a mediator, think of middleman, and no final decision is made. And this concludes our podcast on structures of American law.